No, remove my face. Yes. Remove the face. Then see now.
Good morning, Council. Good morning, Council. Or good afternoon. Good afternoon.
Good afternoon, my lord. Good afternoon, my lord.
The court is ready. We are starting the sitting now.
As the court pleases.
Registrar, call the case. Call case number 1 on the list.
Okay, my lord.
Call case number 1 on the list.
Yes, my lord. Resume today, 10th June 2021, virtually before His Lordship, Honorable Justice Sanusi Kado, presiding. Suit number NICN ABJ 344-2017 between ASCI Irana Abdullahi and Comptroller General of Custom and another. My lord, the parties are absent.
Any appearance? Appearance? Any appearance? Any appearance in NICN stroke ABJ stroke 344 stroke 2017 ASCI Imran Abdullahi versus the Controller General of Custom Service and another. Any appearance? Parties absent, no legal representation. This matter is for judgment. The judgment of the court is ready. Who is it? Judgment of the March 2000, when counsel for the claimant adopted his final written address and urged the court to deem the defendant's final written address as having been argued. The matter was adjourned to 24th day of May 2021 for judgment. However, due to the ongoing strike by the JUSUN, the Judicial Staff Union, the judgment could not be delivered on 24th day of May 2021. That's why it is being delivered today. The judgment goes like this. The fact of this case, as can be gathered from the originating process and the defense filed by the defendant, are to the effect that the claimant was enlisted into the Nigerian Customs Service by the Exhibit 8, his letter of enlistment. He was confirmed by the Exhibit B, and he was promoted to the rank of Assistant Superintendent of Custom 1, Consul 09 by the Exhibit C. However, on the 13th day of March 2017, the claimant received a query Exhibit D, which is same with Exhibit DWH, wherein it was alleged that the claimant on the 18th day of January 2017 examined 1 by 40 feet container, where it was discovered where the 40 container containing 661 pump action rifles, where 661 pump action rifles were concealed, and he fraudulently presented wrong examination report. The claimant responded to the query by the Exhibit E1 to 2, which is the same with Exhibit DWF tendered by the defendant, wherein the claimant denied participation in the alleged examination of the said container in question. The claimant stated that he was dismissed based on unsigned report and that the allegation against him was untrue and his dismissal was done in bad faith and unconstitutional. As the first defendant ignored all the representation he made, both in his reply to the query and before the committee. The claimant stated that by by the letter dated 14th day of August 2017, served on him on the 28th day of August 2017. He was dismissed from his job, and his dismissal was made retrospectively from 4th day of May 2017. Exhibit G by the Exhibit G, which is same as Exhibit DWB. The claimant alleged violation of rules of natural justice. He also stated that his dismissal purportedly carried out by the defendants on the approval of the President of the Federal Republic of Nigeria is contrary to the public service rules, Constitution, and the Nigeria Custom Service Management Act. Based on the above facts, the claimant on 24th day of November 2017 took out a general form of complaint to challenge his dismissal from service. The complaint was accompanied by a statement of facts, witness statement on oath, list of witnesses, and list of documents to be relied on at the trial, and photocopies of the document to be tendered at the trial. By the paragraph 28 of the statement of facts, the claimant phrased for the following reliefs. A declaration that the purported letter of dismissal served on the claimant on the 28th day of August 2017, but dated 14th day of August 2017, is altogether null and void and of no effect, consequence whatsoever. B, an order of court compelling the defendant to reinstate the claimant and effect forthwith payment of all benefits due to him from the date of his purported suspension till his due date of retirement from service. Alternatively, an order of court compelling the defendant to pay the claimant his salaries, bonuses, and other entitlements from May 2017, when he was suspended till retirement or due termination of his employment. D, an order of court compelling the defendant to issue a public apology in 2 national dailies for unlawful dismissal, deliberate humiliation, harassment, intimidation, and detention of the claimant. D, general damages. F, cost of this suit. Upon being served with the claimant's originating process commencing this suit, the defendants, with leave of court, file a joint statement of defense dated 8th day of November 2018, but filed on the 14th day of November 2018. With the leave of court granted on the 18th day of March 2020, the defendant amended their joint statement of defense dated the 3rd day of January 2020 and filed on the 15th day of January 2020. The joint statement of defense was deemed properly filed on the 13th day of March 2020. The defendants, in their amended statement of defense, insisted that the dismissal of the claimant from the service was proper and in accordance with the law. According to the defendants, on the 23rd day of January 2017, the Nigeria Customs Service received information that 1 by 40 feet container number FONU 8259143 was intercepted by officers of the Federal Operation Unit, Zone A, Lagos. The container was found. The container was found to have been, the container was released from Afafa Fort. And it was found to have 661 pump action rifles, which are prohibited items, which are on the import for being arms are in the prohibited list. Upon subjecting the container to the 100% inspection, and upon the finding of the items that were concealed, investigation was launched by the defendant to unravel how it happens. The claimant appeared before the investigation committee together with other officers suspected to have been involved in the release of the container, which with wrong examination report. The investigation indicted the claimant of culpability in the examination report used to get the container released without proper examination. The committee recommended that the claimant to be charged before senior disciplinary committee for misconduct. However, before the claimant appeared before the disciplinary committee by the Exhibit F, letter dated 30th day of May 2017, the claimant was suspended from duty for not examining the 1x40 FT container for new 8259143 with SGD number 32990 of 18th day of January 2017, concealed with 661 pieces of arms, pump action rifles, but wrote a false examination report and presented it having examined the container. The claimant appeared before the disciplinary committee, and at the end of the hearing, he was found culpable, and the committee recommended him for dismissal. The management of the Nigerian Customs Service at its meeting deliberated on the case of the claimant and upheld the recommendation of the senior disciplinary committee. On the potency of Exhibit DWG, the case of the claimant and other senior officers who were indicted for serious misconduct in connection with the intercepted container containing the concealed pump action rifles was forwarded to the president for further action, who approved dismissal of the claimant from service with effect from 4th day of May 2017. On 18th day of March 2020, one Uzemere EO, an assistant superintendent of custom, the claimant on 18th day of March 2021, Uzemere EO, an assistant superintendent of custom 1, testified in defense of the defendant as DW1. DW1, after identifying his witness statement on oath, tendered document in evidence which were admitted and marked as Exhibit DWA to DWH. Under cross-examination, DW1 stated that he adopted regular forensics procedure in carrying out the examination of the handwriting of the claimant. He had carried out more than 10 analyses in the course of his work. All the analyses were carried out on behalf of the Nigerian Custom. If there is any request from sister agency, he was not aware of it. He was not under oath when he did the report. He has not done any publication in this field. The analysis was done by scanning of the originals. The claimant did not do any handwriting in his presence. He was not told whether they were his handwriting. After his investigation, he wrote his report. He did matching with the claimant's signature on the statement and on the questions. He affirmed paragraph 37. DW1 also read page 14 of Exhibit DWE. Exhibit DWC predate his report as he prepared his report in April 2017. He is not a member of the investigation committee and was not a member of the disciplinary committee. DW1 confirmed paragraph 43 of his witness statement on oath. He did not sought the approval of the president to dismiss the claimant. Also, he did not set his eye on the document forwarding the name of the claimant to the president. His involvement is limited to analyzing handwriting, analyzing of the handwriting. At the end of cross-examination and in the absence of re-examination, DW1 was discharged. The submission of the defendant formulated 2 issues for determinations. They are: 1, whether the claimant has proved his case on balance of probabilities to entitle him to relief sought. 2, whether the president is empowered to exercise executive power under section 5(1)(a) and (b) of the to approve the dismissal of the claimant. The argument of the counsel on the 2 issues formulated have been captured in the body of the judgment, so counsel will have the opportunity of reading the submissions when they get the hard copy. The submission of the claimant. The claimants also submitted 2 issues for determinations. They are whether the dismissal of the claimant by the defendant was proper and in accordance with due process of law. 2, whether the claimant is entitled to relief sought he seeks before the Honorable Court. Argument of counsel on these 2 issues, as canvassed in the final written address, have been captured in the body of the judgment. At the end, counsel asked the court to grant all the relief sought by the claimant. Court decision. I have carefully considered the processes filed in this court. In this case, evidence led by and submissions of counsel in the final written addresses filed before the court. The counsel for the parties have each formulated 2 issues for resolution. I found issues formulated by the counsel saying the same thing, though couched in different words. To my mind, a single issue will resolve the dispute submitted by the parties, to wit, whether the claimant has proved entitlement to the relief sought before the court. It is tried law that in employment matters, whether with statutory labor or at common law, a party challenging wrongfulness of termination or appointment has a bounden duty of establishing that his employment, establishment of the conditions of his service, as well as establish how the dependent breach the conditions of service. See the case of Emokpe versus University of Benin. See also University of Calabar versus ASEAN. See also Ogan and Azanada versus Liquefied Natural Gas Limited. In the letter of dismissal Exhibit G, it was stated in paragraph 1 that, I quote, I am directed to convey to you approval of Mr. President and Commander-in-Chief of the Armed Forces, Federal Republic of Nigeria, that you are hereby dismissed of my team for your involvement in the case of fraudulently presented wrong examination report and offense punishable under PRS 03042 and 030401 in bracket W. It is the contention of claimant that his dismissal from the Nigerian Customs Service as conveyed to him in exhibit as quoted above was not in accordance with the law, since his employment has statutory labor that require observance of due process. It was the position of the claimant that exhibit DWG, which the defendant relied in the absence of the board of the second defendant, that has the requisite power to dismiss or discipline him is contrary to the provisions of Section 4.2 of the Nigeria Customs Service Management Board Act, which compass on the board power of dismissal and discipline. It was also argued that the absence of the board has made issuance of query and suspension null and void. The defendant in reaction submitted that in dismissing the claimant from service, the president was acting in the absence of the board in exercising executive power under Section 5, subsection 1A and B of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The defendant also refers to paragraph 2 of Exhibit A and submitted that the claimant's appointment was at the pleasure of the president, so it can be determined at will by the president. The claimant has also insisted that he never examined the container in question, nor was he scheduled to be among officers to inspect or examine the said container. He was also not directed by any superior officer to carry out inspection or examination of the container in question. It was argued that the defendant had onus to establish that he was involved in examination of the container in question. It was submitted on behalf of the claimant that Exhibit DWE, the forensic report, which was relied upon by the defendant to indict the claimant, should be discountenanced as it is not reliable, considering the submission in paragraph 14 of the report. Counsel questions why the panel that tried the claimant should accept the report Exhibit DWE and act on it. Counsel also stated that the forensic report Exhibit DWE was dated 26th day of April 2017 and the investigation report dated 15th day of February 2017. Based on this, counsel for the claimant wonders how the defendants were able to come to the conclusion they reached as per paragraph 452 of the investigation report, even before the handwriting of the claimant was examined and analyzed by experts. Having examined the entire process filed in this suit, it is clear to me that there is no dispute that upon receipt of interception, upon receipt of the information about the interception of a container by the Federal Operation Unit Zone A Lagos, and upon discovery that the content and upon subjecting the container to 100% examination and discovery that it was released from Apapa Port and contains 601 pump action rifles, which were in the import prohibition list. The defendants promptly set up an investigation committee, which is swung into action. In the course of the investigation, several documents were examined by the committee and interviewed persons, including the claimant, suspected to be connected with the release of the container containing the prohibition item. At the end of the investigation, the committee found the claimant to be among the persons or officers culpable of violation examination procedures. The committee recommended disciplinary action against the claimant together with other officers indicted along with him. See Exhibit DWC. Based on the recommendation of the investigation committee, the claimant appeared before the disciplinary committee, at the end of which he was recommended for dismissal from service. However, due to the absence of the board of the second defendant, that was empowered by law to dismiss or discipline the claimant in line with Section 4 of the Nigeria Customs Service Management Board Act, the case of the claimant was referred to the President and Commander-in-Chief of the Federal Republic of Nigeria for further action. This was done in line with this, according to the claimant. This, according to the defendants, was done in line with Exhibit DWG. The President, in turn, approved dismissal of the claimant from service. See Exhibit G, the letter of dismissal. let me straight away say that in an action where employment is with statutory labor, the law requires strict compliance. The law requires strict compliance with the statutory provision in determining the employment. Thus, in determining any employment that is protected by statute or what is termed as statutory employment with statutory labor, as in this case, compliance with the laid down rules and regulation is mandatory. Any deviation or somersault is following the appropriate procedure by the authority or body charged with the responsibility of taking disciplinary action against the employee will be shaped and nullify the entire processes, and any action result emanating from such exercise will amount to nothing. There is no shortcut. Once the employment is protected by statutory provision, appropriate procedure must be adopted in bringing the relationship to an end. See the case of Iderima versus River State Civil Service Commission. See also Shita Bay versus Public Service Commission. See also River State Newspaper Corporation versus Lagos Corporation. See also University of Lagos versus Olanian, and another versus, and also TBN versus Iguilo. On the issue of forensic report, let me state that a forensic report, being an expert opinion, is acceptable in law to prove or disprove what is sought to be established. See the case of Amosun versus INEC and others, 2010 LPLR 4943 CA. The counsel for the claimant asked the court to discountenance the forensic report based on the submissions made in page 14. In page 14 of the report, which DW1 read in open court. Which DW1 read in open court under cross-examination. I have examined the entire report. I wish to state that the law is right in construing a document. The document as a whole must be considered and not to be taken in piecemeal, as the claimant wants this course to do. If the forensic report is to be considered, it has to be in totality. And not to pick what is favorable to the party and ignore those parts that are unfavorable. Therefore, in giving Exhibit DW a holistic consideration, I am of the view that the said document is properly before the court and can be considered. In the case at hand, the main grounds of the claimant is that his dismissal was in breach of the provisions of natural justice. See paragraph 20 of the statement of fact. It is in evidence that the claimant was issued with query Exhibit D. This was after the investigation conducted on the involvement of the claimant in the release of container in question. The investigation report is Exhibit DWC, the claimant by the Exhibit E1 to 2, and Exhibit DWF, which are the same, replies to Exhibit D. Thereafter, the claimant appeared before the disciplinary committee. These facts were not denied by the claimant. In view of the finding that the claimant was queried, he appeared before the disciplinary committee, and he has not impugned or make any allegation against the committee for breach of natural justice. I am of the view that there is no breach of natural justice. I'm standing in this view by the fact that the claimant has not made any allegation of denial of access to any information or document or prevented from making representation before the disciplinary committee. On the issue of whether the claimant was scheduled or directed to examine the container in question, which led to inspection to institution of disciplinary proceeding against the claimant, those are issues that are within the purview of the disciplinary committee. This court cannot sit on appellate, cannot sit on appeal on the decision of the disciplinary committee. It cannot rehear the case of the case that has already been determined by the disciplinary committee. The concern of this court is in the area of compliance with the procedure. In the circumstances, the acceptance of Exhibit DWE by the disciplinary committee to find the claimant culpable cannot be reviewed by this court, where there was no evidence to show that the disciplinary committee denied the claimant fair hearing. In Bill Construction Company Limited versus Imani and Sons Limited, Onogen JSC, as his then was, stated as follows: where a party is given ample opportunity to present his case within the confines of the law, but chooses not to utilize them, he cannot later be having appeared before the disciplinary committee, cannot now turn and claim denial of fair hearing without supplying the facts and evidence to establish such denial. The claimant on the invalidity of his dismissal has argued that the president has no power under the law establishing the second defendant to dismiss the claimant from service, as that power belongs to board of the second defendant. And in the absence of the board, even the query and suspension letters issued to him were null and void and of no effect whatsoever. The response of the defendant was hinged on Exhibit DWG, the circular from the office of the Secretary to the government of the Federation that dissolved all the boards and parastatal and directed them to direct any issues that requires attention of the board to the president through the permanent secretary of their supervising ministry. It is right law that circulars of government are meant for dissemination of information regarding government policies in administration. They are never law or meant to have force of law, as they cannot establish any right, as they have not undergone the process of legislation, and they are not made pursuant to any law that conferred the maker with the legislative power. I must say that circular cannot be used to amend, can also not be used to amend a law or any part of provisions of a law. This means that the reliance on Exhibit DWG by the defendant to argue that the letter of dismissal was proper, as it was in response to Exhibit DWG, and absence of the board of the second defendant, cannot be sustained and cannot stand in the face of the extant statutory provision regulating dismissal of the claimant. See Section 4, subsection 2B of the Nigeria Nigeria Customs Service Management Act. The apex court in the case of Maidiribe versus FRN reported in 2013 LPLR 21861 and circulars held that the administrative law book 8th edition co-authored by Professor W. Wade and C. Post, page 851, throw light on the status of departmental circulars. Generally, such circulars are a common form of administrative document by which instruction and are disseminated. Many such circulars are identified by serial numbers and published, and many of them contain general statement of policy. They are therefore of great importance to the public, giving much guidance about governmental organization and the exercise of discretionary powers in themselves. They have no legal effect whatsoever, having no statutory authority. Exhibit PD16Z is not known to law and therefore cannot create offense because it was not shown to have been issued under an order, act, law, or statute. In the absence of statutory authority in the said exhibit PD16Z or legal notice, it cannot be said have any legal effect. See the unquote, Maidiribe versus FRN. Applying these provisions of the law to the present case, it is my view that the provisions of exhibit DWG cannot be used to modify or amend the provisions of section 4, subsection 2B of the Nigeria Customs Service Management Act, which provide for dismissal of the claimant and the authority that was empowered to dismiss the claimant. All in the circumstances, the submission of counsel, the submission of counsel for the defendant that the dismissal of the claimant by the exhibit G was in line with section 5. In line with section 5(1)(a) and (b) of the Constitution of the Federal Republic of Nigeria as amended cannot be justified as the exercise of executive power of the president by the provisions of the Constitution relied on by the defendant is circumscribed by the constitutional provision in that such exercise must be in accordance with the Constitution and laws. In the case at hand, section 42B of the Nigerian Customs Service Management Board Act has provided has made ample provisions on dismissal. In the circumstances, the provisions of section 5(1) of the Constitution cannot be used to invest on the president the power to dismiss the claimant. This means the dismissal of the claimant having not been carried out in compliance with the provisions of section 4(2)(b) of the Nigerian Customs Service Management Board cannot stand, as it is ultra-biased to the powers of the president. It has also been suggested in the argument of the claimant that in the absence of the board, the second defendant, in the absence of the board of the second defendant, no action can be taken against the claimant. That's why the claimant argued that the query and letter of suspensions issued to him were null and void. This argument of the claimant does not accord with sense of justice. I am of the firm view it's not in consonance with the with the sense of justice and common sense. I am of the firm view that in the absence of the vote, there cannot be any vacancy, as there is management of the second defendant in place. It has been shown that the disciplinary report was accepted by the management of the second defendant. This means that the management of the second defendant can, in the absence of the vote, take disciplinary action against any erring member of staff of the second defendant. The absence of the vote of the second defendant should not be a license for employees of the second defendant to do whatever they like and check. It is in view of my finding that I found the case of Hart versus military governor of Rivers State very apt and applicable to this case. In that case, the military governor of Rivers State directed that the appellant be retired from service. This followed the recommendation of the dismissal of the claimant by the public service of Rivers State. After disciplinary action has been taken against the appellant on misconduct bordering on corruptions and abuse of office, the Supreme Court, while affirming the decision of the trial court on the sanctity of the disciplinary proceedings of the Public Service Commission, and voiding the retirement of the appellant by the military governor, ordered the case to be remitted to the Public Service Commission for implementation. Of the disciplinary proceeding. In the circumstances of this case, and in view of my finding that the submissions of the disciplinary action against the claimant to the president was not proper, I also ordered that this case be remitted back to the board of the second defendant or the management for appropriate disciplinary action. In taking this stand, in applying the case of Hart versus military governor of Rivers State, I am not unaware of the decision of the Court of Appeal Calabar Division in the case of Nawa versus Cross River State Governor, reported in 2007, where the Court of Appeal nullified the retirement of the appellant and ordered his reinstatement back to the service. The reason being that in Nawa's case, there was no disciplinary action taken against the appellant. The decision on retirement of the appellant was made by the governor and communicated to the Civil Service Commission to implement. That's why the Court of Appeal nullified the retirement and reinstated the claimant back to the service of Cross River State. The case at hand was based on disciplinary action, as in the case of Hart. As in the case of Hart's case, that's why I found the Hart case very apt and applicable to this case, and I so apply it to this case and ordered that the disciplinary action be remitted back to the board of the second defendant for appropriate action. Having ordered this case to be remitted to the board of the second defendant, it is necessary to consider the alternative reliefs as it is not necessary to consider the alternative reliefs of the claimant. As the law is well settled that in an action where an alternative claim is made, in addition to the main or principal claim, it is only where the main claim has not been granted or partially granted that consideration of the grant of the alternative reliefs can arise. Both the main claim and the alternative claim cannot at the same time be granted. See the case of UBA versus Mustafa, LPLR. See also the governor of Akwa Ibom State versus Rabelat Nigeria Limited. The philosophy behind the rules on alternative claims or reliefs is that one cannot be expected to obtain two claims that are alternate to each other. One can only obtain one or the other, not both at the same time. For avoidance of doubt, the order of the court is as follows: that the president does not have the power under Section 5, subsection 1 of the Constitution, Federal Republic of Nigeria, as amended, under the exercise of executive power to dismiss claimant from service as per Exhibit G retrospectively. Exhibit G is hereby, in the circumstances, Exhibit G is hereby set aside for having been issued without requisite power. The proceeding before the board management or the management be and is hereby remitted back to the management, back to the board, so as to exercise its power under Section 4 of the Nigeria Customs Service Management Board as it may deem fit. I also award cost in favor of the claimant in the sum of 1 million naira. Judgment entered accordingly.
As the court pleases.
As the court pleases.
Most grateful, my lord. I'm sorry I joined late. Francis Oronsaye for the claimant.
Okay.
I said, most grateful, my lord, for the judgment of this honorable court.
Yes.
But Francis Oronsaye for the claimant. I apologize for joining late.
For the claimant.
Yes, my lord.
Yes, any other appearance? What about the defendants?
Well, I can't find them online. I don't think they are present.
You can, by tomorrow, you can access the judgment of the court on our website before you get the
Most
hard
grateful,
copy
sir.
when the court resume on after the
Tuesday.
The Justin strike, which has been called off.
As the court pleases.
Yes, registrar, call the next case.
Yes, my lord. Suit number NICN CA 09-2020 between 1, Comrade Prince Udoma Ewona, 2, Comrade Ako Basin, 3, Comrade Victor Epo, 4, Comrade Ogu James, 5, Comrade Ade Abang, 6, Comrade Aret Asuko, and 1, the Nigeria Civil Service Union. 2, Nigerian Civil Service Union, Cross River State Council. 3, Raymond Afu. 4, Oko Antiga. 5, Felicia Abue. 6, Kanu Mba. 7, Henry Bassin. 8, Paulinus Eno. My lord, all the parties are absent.
Appearance.
May it please my lord.
Yes.
Yes, may it please my lord. Kehole
Yes.
Enya. Kehole
Eke.
Enya. Kehole,
Eke.
my lord. Kehole, Kehole. Enya, ENYA.
Are you appearing for who?
Yes, my lord, I'm appearing for the claimants. All the claimants, my lord.
Yes. Any appearance for the defendants? Any
My lord, I've not
appearance
seen-
for the defendants?
I'm not seeing them online.
This matter is for ruling. It goes like this. This deal with motion on notice dated 5th day of February 2021 and filed on the 10th day of February 2021 by the defendant's applicant frame for striking out of this suit. The motion on notice was brought pursuant to Order 17 Rule 1 of the National Industrial Code Civil Procedure Rules and under the inherent jurisdiction of the court. The grounds for seeking the striking out of this suit were given as follows. The claimants have failed, refused, or neglected to join necessary parties. The failure of the claimants to join the team of delegates led by Comrade Godson Anuchi, who conducted the election under Godson Anuchi, is fatal, and the claimant's case, as this court may not be able to unearth the truth, irrespective of the allegation against which touches the roots of the claimant's case, without the team that conducted and submitted a single issue for determination to it, whether the failure of the claimants to join the team of delegates, as well as Comrade Godson Anuchi, whose grievous allegation had been made against in the conduct of the election under attack, is not fatal to the claimant's case. In arguing the sole issue for resolution, counsel submitted that the subject matter of this suit is the election into the executive of the first and second respondent, which election is under scrutiny or attack, which the claimants want to the court to avoid or nullify for illegality surrounding participation and conduct of the election. According to counsel, Comrade Godwin Anuchi and his team that conducted election, which is under attack, they are vital and fundamental to this proceeding as allegations have been made against them. It is only legal and proper for them to be heard. Counsel on this relied on Section 36 of the Constitution of the Federal Republic of Nigeria on fair hearing. According to counsel, it is mandatory to join the said persons or officers who conducted the said election, based on which grievous allegation has been made against them. On this contention, counsel called on the case of Michael Joy Onwudijo versus Joseph Dinobi, reported in 2006 NWLR Part 961, page 2, page 324. Counsel insisted that the members of the committee that organized the election are very necessary parties. They ought to be joined. Their absence will make the court not to be able to effectively and efficiently determine the claimant's claim. Reliance was also placed on the case of Remadueke, 2019, 7 Nigerian Wukilolo report, part 1671, page 255 at 267. In concluding his submission, counsel urged the court to strike out the claimant case. In reaction to the defendant's motion on notice, the claimants on 9th day of March 2021 filed a written address in opposition to the defendant's application. In the written address, the claimant submitted a sole issue for resolution to it, whether there is any merit in the application of the defendant to merit the ruling of this court in its favor. James Ibo Esquire, counsel for the claimant, in arguing the sole issue for resolution, submitted that subject to matter of this suit is election conducted into position or offices of the second defendant's applicant. which is the chapter of the second of the first defendant applicant. The said election was conducted and supervised by a team of delegates appointed by the first defendant applicant, headed by Assistant Secretary General of the first defendant applicant, Godwin Anuchi. According to counsel, the main grounds of the claimant is that the team appointed by the first defendant to conduct the election into the executive offices of the second defendant, executive officers of the second defendant is intentionally and grossly compromise the election process by allowing non-due paying members of the union to participate in the election in sheer contravention of the provisions of the 2019 Constitution of the Union as amended. It is submitted that the members of the committee that conducted the election being challenged were for all intent and purposes acting for and on behalf of the first defendant as its agent or representative. Counsel referred to the case of Cotecna International Limited versus Churchgate Nigeria Limited and another, reported in 2010 LPELR 897SC, where the Supreme Court defined agent to mean one who is authorized to act for in place of another or a representative. Counsel submitted that it is absurdity of high magnitude to argue that the members of the committee that mandatorily conducted election are necessary parties and they must be joined in this suit. Counsel posited that the members of the committee that conducted election are agents of the defendant, having sued the defendant's agents are not necessary parties. It is settled that where an agent has performed an act authorized by the principal, the principal an act authorized, the principal assume full responsibility. Counsel likened the present action to a situation where Independent Electoral Commission conducted election using electoral officers and supervisors. Suing electoral officers and supervisors is superfluous. On this submission, counsel relied on the case of Paimi and another versus Oni and another, reported in 2009 LPLR 4145 CA. Counsel also refers to the case of Agagu versus Mimiko, reported in 2009 LPELR 21149 CA, where it was held non-joiner of returning officers, an electoral officer, or a presiding officer to election petition will not have any adverse effect on the petition. The petition subsists notwithstanding non-joiner of electoral officers. Counsel also submitted that the law is settled that non-joiner is not fatal to an action as it has nothing to do with competency of an action. On this submission, counsel relied on Anyawoko versus Okoye, reported in 2010 5 Nigerian Law Report, Part 1188. See also Bello versus INEC 2010 LPLR 767 SC. Counsel submitted that the application of the defendant is incongruous. Is incongruous, frivolous, vexatious, bereft of scintilla of merit, and is a deliberate and calculated attempt by the defendant to delay or stall the progress or hearing of this suit in order to perpetuate their illegal stay and occupation of the executive position offices of the second defendant, which is tenure-based and time is already running against the claimant and their interest. In concluding his submission, counsel urged the court that there is no merit in the defendant's application and same should be dismissed with 200,000 naira court. Upon being served with the claimant written address in opposition to the defendants on the 15th day of March 2021, filed a rejoinder on the point of law. In the written address, it was argued that the case cited by the claimants in their written address are inapplicable. They do not support the respondent case. The cases do not avail the claimants as they are cited out of context. Counsel submitted cases should not be cited as mere jingle. In support of this submission, the case of NNPC versus Auta 2000, reported in 2000, FWLR part 26, page 1768 was relied on. In conclusion, his submission, counsel asked the court to discountenance the claimant address of 9th day of March 2021 and grant the defendant application and cost of 250,000 naira. Court decision. I have carefully perused the motion on notice filed by the defendants and its supporting affidavit. I have equally considered the written I have equally considered the written address filed by the defendants along with the motion on notice, the claimant's written address in opposition to the motion on notice, and the rejoinder reply on the point of law filed by the defendant in response to the defendant's written address in opposition. I have also listened attentively to the oral submissions of counsel combating the position of their respective clients. It is clear to me that the defendant's motion on notice in contesting non-joinder of persons they perceive to be necessary to be made parties in this suit. Therefore, the question to be resolved is whether the defendants are entitled to the praise contained in the motion paper. I shall start my consideration of the motion on notice by making reference to Order 13 of the rules of this court, which made ample provisions on parties to a suit. The relevant provisions of the rules to the determination of the defendant's applications is Order 13, Rule 4, Rule 6, Sub Rule 1, Rule 7, Sub Rule 7, and Rule 11, Sub Rule 3, and Sub Rule 4 under. I have reproduced, I don't need to go through them. Counsel will read the provision. The provisions of Order 13, Rule 4 of the rules of this court clearly stated that all persons may be joined as defendants against whom the right to any relief is alleged to exist, whether jointly, separately, or in the alternative. And judgment may be given against such one or more of the defendants as may be found to be liable according to their respective liabilities without any amendment. By Order 13, Rule 6, Sub Rule 1, it shall not be necessary for every defendant to be interested in all the relief spread or as to every cause of action included in any proceeding against such a defendant. By Order 13, Rule 7 of a claimant may, at the claimant's option, join as parties to the same action all or any of the persons separately or jointly and separately liable on any reliefs in the matter. By Order 11, Rule 3 and 4, Sub Rule 3 and 4, a person who has an interest in the determination of a matter by the court may apply to be joined as a party to the proceedings. Where in any matter before the court, a party wishes to join a third party who is not a party to the proceeding, the first party may apply to the court to join third party to the action. The provisions of these rules which deal with joinder or misjoinder of parties to a suit are very clear and unambiguous. In the case at hand, the claimant sued the first to seventh defendant challenging the conduct of election to the various executive offices. Various executive offices of the second defendant, in which at the election being challenged, the third and seventh defendant were declared winners of the positions contested. The defendants are now contesting the competency of this suit due to alleged non-inclusion of the chairman and members of the committee that conducted the election, which is the subject of this suit. According to the defendant, the chairman and members of the committee that organized the election being challenged are necessary parties without which this suit cannot be effectively and effectually settled by the court. The claimants argued for contra and maintained that the chairman, Mr. Godwin Anuchi, and members of his committee are not necessary parties, as they conducted the election on behalf of the first and second defendant. The rationale behind joinder of parties is to ensure that parties that are very crucial to determination of a case have not been left out. This is to say that the claimant is only obliged by the rules of court to join only defendants against whom any right to relief is alleged to have existed. Likewise, persons who claim any share, interest, or who may be affected in one way or the other by the suit may apply to be joined as parties. It is apparent from the clear and unambiguous provisions of the rules of the court that for the defendant to succeed in their application, they have the bounden duty of establishing that the chairman and members of the committee that organize the election, which is subject of this suit, who are not parties before the court, ought to be joined, or that their presence before the court may be necessary in order to enable court effectually and completely to adjudicate upon the set and settle all the questions involved in this case. It is clear from the rules of court cited above, where a person complains of non-joinder, as the defendant seems to be doing, the only reason why they should be joined is that they are necessary parties who should be bound by the result of the action. And the crucial question to be determined as to whether it is necessary, is that they are necessary parties who should be bound by the result of the action. And the crucial question to be determined as to whether he is a necessary party is whether the issue in the action cannot be effectually and completely settled unless they are parties. See the case Oriare versus Government of Western Nigeria. See also Uku versus Oku Magba. See Alhaji Raji Oduola and Koka. In the celebrated case of Pino Investment Limited versus Hotel Presidential Limited, the Supreme Court, as far Idive JSC of blessed memory, put the question to whether plaintiffs should have been joined the Rivers State government in order for the suit to effectually and completely settle all the question in controversy. See also Oputa J as his name was in Edward Egono and others versus Ezamaka Egono, where he posited rightly that the rules as to joinder of parties are not intended to add more defendants to an existing suit just for the convenience of the defendants or record. It is clear from the above decisions of the Apex Court that the rules of court on joinder are not meant or intended to add defendants who had no interest in the matter before the court. It is only against whom right to relief exists that can be made parties to an action, or parties who have interest or who are interested in the subject matter of dispute or may be affected by the outcome that can be made parties, where, however, the presence of such parties is not necessary for the court's adjudication, the claimants are not obliged to make them parties. Having regard to the tried position of the law, the pertinent question to ask is whether chairman and members of the committee that organize elections that is subject of this suit are pivotal to the determination of this suit before the court. There is no disputing the fact that the chairman and members of the committee that conducted the election that produced third and seventh defendants were appointed by the first defendant to organize the election into executive offices of the second defendant. The committee has completed its assignment and the first and second defendants have accepted the outcome of the election without any qualm. See paragraphs 5, 6, 7, 8 of the statement of fact. From the foregoing, it is clear to me, as submitted by the counsel for the claimants, that the claimants and members of the committee that organize the election being challenged are agents of the first defendant. Therefore, being agent of a disclosed principal, they are not necessary parties to the suit. The reason being that their action is the action of the their principal, i.e. the first defendant. The claimants having joined the first claimant, having joined the first defendant, who is the principal of the chairman and members of the organizing committee of the election being challenged, have obviated the necessity of joining or making the claimant and members of the committee parties to this suit. Their absence from this suit will not jeopardize the determination of the rights of the parties before the court. An agent acting on behalf of a non-principal incur no liability. This is because the act of the agent is the act of the principal. The situation is as if it was the principal that was the agent. It was the principal that was the agent, did or omitted to do what the agent omitted to do. The common law rule is expressed in the Latin maxim, quid facit per alium facet face ipsam facere bindua, which means he who does an act, he who does an act through another person is deemed in law to do it himself. See the case of Esang versus Arole Plastic Industries Limited, 2002, 17 Nigerian Law Report, part 795. So also Orie Bosi versus Andy Sam Investment Company Limited. See also Adiosun Apolabi versus Apolabi, and the case of Niger Progress Limited versus Northeastern Line Corporation, reported in 1989 LPLR 1996 SC. The defendants have not also shown how the outcome of the decision of the court will affect the chairman and members of the committee. The defendants have not also disclosed their interest in the subject matter of this dispute between the parties before the court. Assuming the chairman and members of the committee that organize the election are necessary parties, it is the duty of the claimant who make them parties, or they themselves, if they are interested, or if their interest is at stake, or they would one way or the other be adversely affected by the outcome of the suit, to apply to the court for them to be joined in order to protect their interests. The defendants have no business under the rules of court. Have no business under the rules of court bringing this kind of application. The defendant would have been on firm ground if they had argued that they are not necessary parties. Their names should be struck out. The defendants can only speak for themselves and not for other parties who are not before the court, who did not see anything wrong with the action of the claimant. The defendants have put themselves in a position of crying more than the breed. Taking into consideration the entire facts as disclosed from the originating process, the motion on notice, and the affidavit in support, I have no doubt in my mind that the claimants and members of the committee that conducted the election being challenged before the court have no business being made parties in this suit, as the case can be effectively and effectually and completely determined without them being made parties. This is because the central question in this suit, which borders on validity of election, can effectively and completely settle without them being joined as parties to the suit. They are therefore not necessary parties to this suit. As agent of the first defendant, their presence is not necessary since their principal has been made a party to this suit. As the Supreme Court in Green and Green put it, necessary parties are those who are not only interested in the subject matter of the proceedings, but also who, in their absence, the proceeding could not be fairly dealt with. In other words, the question to be settled in the action between the existing parties must be a question which cannot be properly settled unless they are parties to the action instituted by the claimant. In any case, it is judicially settled through a long line of cases that no proceeding shall be defeated by reason of misjoinder or non-joinder of parties, and the court shall deal with the case as presented in respect of the rights of the parties before it. See, in Attorney General of Rivers State and Attorney General of Akwa Ibom State, the Supreme Court held that the courts have held it for quite a long that no cause of action or matter shall be defeated by reason of misjoinder or no joinder of parties, and the court may in every cause of or matter deal with the matter in controversy so far as regards the rights and interests of parties actually before it. This settles the judicial position that has now crystallized into the general principle of law is that the result of consistent enforcement of the court by the over time of the rules of court that save proceeding from being vitiated by non-joinder or misjoinder of parties. Implicit in this principle is that is the notion that provided that the named claimant has the locus standi to bring the action, and the action discloses a course of action for it against the unnamed defendant, the non-joinder of another claimant, with the requisite locus standi or another defendant against whom there is no cause of action should not defeat the proceeding. The court should determine the case as presented by the claimant. All I have been saying above is that the defendants have not made out a case for grant of their application, as the same is baseless without any legal backing. In the circumstances, the defendant's motion on notice is hereby dismissed for lacking in merit. I award 100,000 naira cost against the defendant.
As the court pleases. My lord, we are grateful.
Yes,
for
you are
the
welcome.
sound ruling, my lord. Grateful.
Yes. In view of the way, I will adjourn the matter Senate die next week when the strike is over. We will fix a date and serve you with hearing notice.
As the court pleases. My lord, we are grateful.
Yeah. Yes, thank you very much, Council, for your cooperation. We have come to the end of today's proceedings, and the virtual sitting will end. The administrator of the virtual sitting, you can discontinue with the sitting, as we have come to the end of the proceedings. Thank you.
Thank you, my lord.